Good evening, everyone. Tonight we would like to discuss questions. We have some of the past questions and some of you have also sent some tutorial questions from other institutions, Legon, GIMPA, and all that. I look at the questions and in my view, they are very useful questions. And as I keep telling you, because of the nature of exams that we are doing, no question is useless or irrelevant so long as it falls within the same subject area. And it doesn't matter where it's coming from. Even if it is a question by yourself, and we need to discuss it, it's still relevant because it falls within the 6 examinable areas. Because the purpose of this kind of interactive session is to learn together and revise. So anything which comes up, which we haven't discussed or which you are not sure, you could bring it up for all of us to actually look at it, and then you brainstorm and arrive at the consensus. So that has been the approach, and we intend to stick to that. I think there was some questions from land law, and also like maybe let's look at the constitutional law first. I think there are some constitutional law, a range of questions from GIMPA. I ran my eyes through them, and I think that they are very useful and helpful in the sense that they reflect most of the issues that we have been raising. And if you work through them, I am very confident that at least about 8. Yeah, sorry. Sunday night, I don't know what is wrong with MTN. Both their table nets and also normal, if you wanted to use your hotspot, it doesn't work best. I've noted this for quite some time. Sunday evenings, I have a challenge with internet, so sorry about that. Yeah, so I was just making the point that I'm trying to open that question which I mentioned so that we will run our eyes through some of them. And these questions are from GIMPA. As I told you, it doesn't matter where the questions are coming from. And even if you have some questions you have put together yourself, I think that it's still worth discussing. So this particular question that I received from one of you, let me just share the screen. Yeah, I think these are questions from 2017, 2018, constitutional law class in GIMPA, and they are relevant. They help you to revise most of the things that we have discussed. We need to be learning. So, of course, question 1, the Declaration of Independence of the Gold Coast on 1957 marks the enactment through historic events, the liberation of the chiefs and people of the Gold Coast from the legal effect of the bond of 1844, and the liberation of the British from the legal effect of a promise of Gold Coast self-government made by the Earl of Kimberley, Secretary of State for Colonies on March 10th, 1873. So this is an extract from a statement or a speech which the Venerable Dr. J.B. Dankwa Joseph, who is reputed as a doyen of Gold Coast politics. So that is another expression which we should keep in mind. Mention doyen of the Gold Coast politics. They're referring to no person than Dr. J.B. Dankwa. or Joseph Boachidankwa, as it were. So this is an extract from his speech. And the examiner put this question: with the aid of decided cases and other legal authorities, discuss the legal effect of the bond of 1844. Yeah, so this is a question that we have. We all remember the bond of 1844. So in 1 minute, I would like you to scribble something down, and you can use the chat to share your plan in terms of the points that you highlight for us. So 1 minute, let us quickly and get that done, okay? Question 1. When you are done and you want to share your plan with us, you can do so in the chat. I know you are many, not all of you will be able to do that, but if you get some of you doing that, or as many of you as you want to do, that is fine. If you are done, you can put yours. You can put yours in the chat. Yeah, FJ. FJ. Oh, FJ, yeah, you can mute yourself.
Okay. Hello.
Yes, I can hear you. FJ.
Yeah. Okay. So please, I logged in late. I wanted to find out what we are doing.
Oh, right. I said that we are running our eyes through a number of questions. I think there are about 42 questions, and they reflect various aspects of constitutional law. So you want to quickly do that, and then when we are done, we will take another land law question from University of Ghana, which one of you sent also to me. And then if there is time, then we'll get back to some of the past questions, or if there is anything in particular somebody will bring up, we can also consider that. Okay, FJ, or you have some other ideas? FJ, do you have some other ideas? Are you there? Okay, I think she's gone. Okay, so let me look at what you have done. Oh, yeah, you can start sharing your ideas. Okay, or if you don't want to do that, I should just okay, so first of all, we have to know what the bond of 1844 is about. And I think that every student of law in Ghana is very much aware that the bond of 1844, as far as the Gold Coast is concerned, in terms of a direct legal engagement between the people along the coast, typically the Fantes, through their chiefs, and the colonial government. Has anyone said anything? Why you don't want to share your ideas? It's too difficult for you? Or you think that is not a question which can come? As I tell you, unless you have, you are the one setting the question, you cannot dismiss any question as useless, isn't it? And bond of 1844 is quite important. Okay, so just in case we have forgotten, we have to note that For a very long time, the Europeans had been trading on the coast and all that. And at some point, we got some British traders or merchants as well. And they be doing a number of things, and they needed to formalize relationship in terms of engagement with the people that they live close with. The famous bond of 1844, an agreement which was signed between the British colonialists, of course, not the merchants at the time, and the chiefs of the Fantes. And this was done on 6 March 1844. That is very significant because when Nkrumah had to declare independence, he strategically and for historic reasons made it happen on 6 March. So the 6th March was not just, if you like, something arbitrary. It was for a reason. Well, he remembered very well that the bond of 1844 was the very first formal agreement by which our people decided to allow these merchants who eventually will become a big colonialists to have anything to do with us. And this was an understanding which essentially was that the British will be allowed to participate in administration of justice. He will sit with the chiefs in administering justice, and at the same time, the local people were going to also abandon certain practices, including pioneering, human sacrifice, or using human being as a security for death and things like that. All those things were supposed to be abandoned by the local people. And then in return for that, colonialists more or less were also supposed to give protection them against the antis, especially who at the time had been fighting the Fantes. So I think these are some of the things we have to remember. We have to highlight the significance of the bond of 1844. What were the rare significance? Maybe if you want to read more, there is which is headed the historical significance of the bond of 1844. I could just push it to you. But what we have stated as some of the basic significance or the benefits of the bond of 1844. So if you, I know you, okay, let me see. Okay, so Jacob, that is fine, that the chiefs of the Confederacy, that is the founding Confederacy, agreed that serious crimes should be tried by British judicial officers, sitting with the chiefs who hold the custom in trust for the people. That is true. And then in relation or in addition to that, to the people or the coasters, that is the Fantes, the local people, the natives, were also supposed to avoid certain obnoxious practices, as I have indicated. So if you read I've gotten like the rare test of the bond. So the rare test of the bond, which I have, goes as follows: that the power and jurisdiction have been exercised on behalf of Her Majesty the Queen of Great Britain within diverse countries and play adjacent to Her Majesty's forts and settlements of the Gold Coast. We, chiefs of countries, will refer to, adjacent to the said fort settlement, do hereby acknowledge that power and jurisdiction and so look at it, that they acknowledge power and jurisdiction. That is the power or the ability of the British, right, to do what? And declare that the first objects of law are protection of individuals and property. You also remember that. So in the bond of 1844, among other things, they said that they recognize that the first object, that is the first objective purpose of having law, is to protect individuals and property. So that is the first one they make. And then the clause 2 in the bond of 1844, they said that human sacrifices and other barbarous customs such as pioneering are abomination. Yeah, sorry. So as I told you earlier on, I think that the internet is not the best, but let's manage. That's when it goes off, we come back. So that's the most important thing. Yeah, so I mentioned other things that apart from understanding by the Fante chiefs and to stop human sacrificing and pioneering, and the bond of 1844 would also stated that clause 3, murders, robberies, and other crimes and offenses will be tried and inquired of before the Queen's judicial officers and the chiefs of the district, molding the customs of the country to the general principles of British law. So another thing which the bond of 1844 sought to do, that it will over time mold, that is tweak, modify, nurture the native law to reflect British law or English understanding of law. So that was another thing that the bond of 1844 sought. So let me share the screen again. Yeah, so we know the content, and then, but of course, let me look at some of you have. Okay, so somebody is saying that you first give a brief historical antecedents of the bond of 1844. Okay, so the brief historical antecedents essentially that the Fantes have been having, fighting various battles with the foresters or those from the countryside, the Ashantis and so, and they had come together in a form of confederation and all that. But then around the same time too, these Europeans, they have established their own settlements, forts, castles, and all that. And they have used their own informal means to be meddling in the affairs of these local people. So it got to a time that it was necessary for consensus to be reached, for a proper agreement to be reached, so that whatever the Europeans were doing with them will be something which has legitimacy. So to give legitimacy to the participation of the British in affairs, settlement of disputes and ensuring law and order within Fanteland or the coast, this agreement was made. So that is one thing we should remember. Then the person said that you discussed the historical significance of the bond. Okay, so what are some of the legal and political significance? We have said that first, it gave legitimacy to the British colonialists in their participation in administration of justice and provision of law and order, right? And again, it also meant that our people had more or less accepted that their customary law was not going to be absolute. Our customary law, our customs and practices were going to be tested for their validity in terms of their consistence with the general principles of justice or fairness as understood under English. And it is this same idea which will later on be developed in the 1876 Supreme Court Ordinance, when it comes to the sources of law, then we'll be told that customary law will have to be a question of us and will have to be proved until it has become so notorious. And then they also say that customary law or native law shall be applied so long as it's not against good conscience, all right? So, because from 1844, you have actually admitted that you would allow your customs and practices. Some of them are barbarous, some of them are not really conducing to fairness and justice, and you allow them to be molded to conform to British or English law. So those are some of the things. And of course, it is the same bond of 1844 which gradually enabled the British to eventually establish a formal colonial administration. Yeah, so you know the politics and all. But then we are told that we should cite cases and other legal authorities trying to discuss the legal effect of the 1844. Of course, in terms of decided cases, we'll have to, I think there's an article I have come across, which I will share with you, and authorities are recited there. Okay, so we cannot waste all the time on that, so let's move on to something else. Discuss contribution of Guggisberg Constitution 1925 to constitutional development in Ghana. Well, it's not a question that I think that we should actually expect in an examination like ours, except that for purposes of the multiple choice, there could be something about Guggisberg's constitution if your examiner was interested in constitutional history of Ghana. And that is why we don't have to just dismiss the Guggisberg constitution. At least we should remember some key features and some key importance of that constitution, just for purposes of multiple choice and not really for composition, because I don't foresee that setting only 2 questions, your examiner will have the luxury of opportunity to just concentrate on just a tiny, just historical question. So, but for multiple choice, there could be something like that. And one thing we should remember about the Guggisberg Constitution is that, first of all, it marked the very first time when the colony elected representation, when the colonial people were allowed to elect their own representative to the Legislative Council, right? So that was a major achievement. If you look at the previous one, sometimes by appointment, nomination, and all that, but for very first time, the Gold Coast colony was allowed to elect its representation. So if you like, that was like an antecedent or foreshadowing of the, the elected, parliamentarians that we have these days. So that's one thing that we should keep in mind. And you also have to remember that there were 14, the Legislative Council was made up of the governor, 14 officials and 15 unofficials. And officials were divided into ex-official members. And the ex-official members, we had like the 13. And then the rest are nominated official members. Yeah, so those are the things that we have to remember. So we had like the provinces. Some of the members were drawn from the various like the provinces. So 3 members from Eastern Province, 2 from Central Provincial Council, 2 from Western Provincial Council, and then 3 municipal members elected by voters of Accra, Cape Coast, and Secondary. And then a member, the European Chamber of Commerce also had a representative from the Legislative Council. And then the Chamber of Mines, where also Europeans also had a representative from the Legislative Council. And then the 3 Europeans nominated by the governor. So I think that these are some of the things that we have to remember. So most importantly, the Guggisberg Constitution, introduced the what do you call the elective representation, that is having your representative chosen by election, as it were. Let's move on to another one. Discuss the main features of any of the post-independence Constitution of Ghana. I'm talking about question 3. So if you're looking at the question 3, identify some of the features which still found the expression in the 1992. Okay, I have shared with you the report of the Constitutional Review Commission, and is a very beautiful report in the sense that if you look at it, I know it's bulky, you cannot look at all, but I can give you some suggestion. Let's say that the portion on the executive, right? The portion on the executive, you have to look at it, the portion on the legislature, and then the judiciary, right? And if you look at the report, what we do in the report is that for each thematic area, we are told what the historical position was. So the antecedents from other constitutions, right? They are stated or briefly summarized. And then we look at the current constitutional position before the which have come up for reform and what the positions are. So it's a very useful document. So if you have a question like question 3, I would like you to put your thoughts down. So 1 minute, put your thoughts down, and then if you want to share whatever you've put down in the chat, let's do that. Discuss the main features of any of the post-independence Constitution of Ghana. Identify some of the features which still find expression in 1992 Constitution. Yeah, so this is a very fair question, which could, for example, be given you and is reasonable. Yeah, so whatever you have, just put it over there and then let's look at it. Question 3. Yeah, we're dealing with question 3 now. Yeah, so put your thoughts down in the chat. It doesn't matter, whatever you'll be able to put together. Just put it there. Yes. Question 3, discuss the main features of any. The question is of any. So any means that any of the post-independent Constitution of Ghana identify some of the features which still find expression in the 1992 Constitution. Very straightforward, isn't it? Okay, so I think one person. Okay, so St. Mugai chose 1979 Constitution. The Court of Appeal was the highest court of the land. The position of the Vice President was the first brought about. Okay, I mean, that's a noble contribution. Yeah, who else? Yeah, my line went off, but I'm back. So who are those who have okay, so okay, Barrister, first select any of the Constitution 69, 79. Identify areas you want to address. Okay, for example, in the judiciary, the legislature, then Angela Autin, Commission of Inquiry has evolved from this 9 Constitution from not being able to appeal the decision of the committee and the finding of the commission being in criminal proceedings. Okay, All right, these are all novel contributions. Let me share the screen again. Oh my, okay, I thought it. Oh, is this? Why? Okay, so I think it's back now. Okay, so somebody chose 1969. Best executive power in the presidential and the prime minister. Okay. Okay, so it's come back. Okay, so because of time, what I will do, let me summarize and guide you where you can get the answer or the material to develop an answer. So in a question like this, talking about the main features, right? And I like the choice you did. I mean, in terms of the post-independent constitution, the major ones, the 69 constitution and then the 79 constitution. Of course, there are others, but for in terms of the constitutional developments which have influenced the 1992 constitution in the way it is, and these are the key ones. And if you take any of them, right, you can decide to take, let's say, like the executive. You can take the executive, the legislature, and the judiciary. These are enough. If you go to the Constitutional Review Commission report that I gave you, these two constitutions, of course, even the others, if you take like the executive, for example, the current arrangements that we have also summarized what the position used to be under the 1969 Constitution. The fact that we have like the presidential, what they call because of the problem we had with the 1960 Constitution, when the president was also the head of government and the head of state and everything, and how totalitarian he became and all that. And remember the infamous Ray Akoto and its aftermath. The framers of the 1969 Constitution and the proposals for that Constitution decided to avoid that. And that was why they said that let's have a system where the president, we have someone who will, we have the president, then we have like the prime minister, right? So that there'll be some, the president will not be too powerful as well. And how the president was also elected by electoral college, so to speak. So look at that. Look at the Constitutional Revision Commission report. All this information are there. And how that also did not help. And then we came to 1979 Constitution. We went back to the typical presidential system, what we call the monocephalous type government. So look at the Constitutional Review Commission, get the necessary material to discuss. So let's move on. Now let's come to question 2, which I think is question 4, which is more pregnant in my view. Critically analyze the extent to which 1992 Constitution of Ghana mirrors 1960, 1969, and 1979 Constitution. Okay, so again, you can, on your own, you can decide to do like the table, right? You can decide to do a table. You can take maybe about 4 areas, or if you like 5, you can tell, let's say, the executive under 1960. What type of executive did we have? How was the president elected, right? And even how was the president sworn in, and what were the powers of appointment of the president? Then you do the same thing for 1969. You do the same thing for 1979. And then 1992, you do the same thing. Then to be quite clear, you can use metrics, just like a table, and then you do that. Then you can take the legislature. In terms of size of parliament, how many MPs were provided for under 1960? right? How many were provided for under 69, 79, 1992? And then you also look at the age, like qualification, like at what age could someone be an MP? Look at 1960, look at 1969, 1979, right? The age for being eligible to be MP. And again, look at this issue. If someone is elected as an MP on a ticket of Party A, and while in Parliament he decides to cross-compare to Party B, what did 1960 Constitution say, or was it silent? What did 1969 Constitution say? And what did 1979 Constitution say? And what does 1992 Constitution also say on that matter? So that is important. So look at some of those things. And then you can also look at private member bills. If you look at the 1960 Constitution, in terms of introducing bill to Parliament, was it only the government that could initiate bill, or private members bill were also allowed? We do the same thing for 69, 79, and then sorry for this breaks. We have no, sorry, that's the MTN. They are not doing their things well. Yeah, so you do the same thing. And then when it comes to the judiciary tool, you try to, you do the table. 1960, what was like the structure like? The structure, did you have Supreme Court, High Courts, and so on? Now, Supreme Court, for example, you could ask, what was like the composition? Then you do the same thing for 1969 Constitution, you do the same thing for 1992 Constitution. Okay, all right. And then once you do that, it will become obvious which of the features of 1960, 69, 79 Constitution are reflected in 1992. That will be too obvious. If you don't want to do that, and you just want a straightforward way, because you don't want to waste time, you can just go to the Constitution Review Commission. Just go to the portion on executive, right? Go to the portion on legislature, portion on the judiciary, and then you are good to go. Maybe one area that you may be interested in finding out is what we call the IBC, independent, ICB, independent constitutional bodies, right? Like the Commission for Human Rights and Administrative Justice, National Commission for Civic Education and all that, and then Electoral Commission, National Media Commission. You may want to find out whether these independent constitutional commissions are first of its kind in 1992, or they have just been carried over from 1979 and 1969 and all that. Okay, and lest I forget, let me just for one thing that you may also want to be thinking about is that as part of your preparation, just think about the independent constitutional bodies, right? You could, for example, be asked to discuss whether they are still useful or whether they need for reform so that they can deliver on their mandate. And in that respect, if you look at the Constitutional Review Commission report, there are useful ideas there. So I would like you to look at that. Question 5 is what are the main features of 1992 Constitution? I mean, these are quite obvious, so we know waste time on that. You know the main features of the 1992 Constitution. Question 6 is just a repetition of what we have. I think there are some matters I saw which I thought were more. Okay, so for example, let's start from question 11, for example. 11. Mawule Doche was born at Agave General Hospital, Togo, 20th day of May. 1958. Mawuli's great-grandfather was born in 1900. Both his father and grandmother were born in 1938 and 1920 respectively at Ohoi, which is now in the Volta region of the Republic of Ghana. Mawuli had his part primary education in Togo, but came to Ghana at age 9. Throughout his entire stay in Ghana, Mawuli has never considered himself a Ghanaian and always strived to keep Togolese cultural life by listening to foreign radio stations that play traditional music from Togo. Mawuli has completed secondary, primary, tertiary education in Ghana. Suddenly, he has developed interest in Ghanaian politics and has indicated to all his friends that he wants to contest the parliamentary elections in the 2016 general election. Being a resident of Ohoi and a friend of Mawuli has warned him not to venture into Ghanaian politics on the grounds that he's not a citizen of Ghana. But Mawuli says that he is Ghanaian. With the aid of relevant authorities, advise Mawuli on this matter. Yeah, so this is a very interesting question. And okay, so now the question that we were looking at is not just that particular question, which is important because of the recent parliamentary election challenges, especially the ascent, what do you call the ascent or whatever, the MP who has been declared as not being qualified to have run for the parliamentary election. So I think that it is not out of place when you are preparing for these exams this year to be interested in citizenship, right? Citizenship, dual citizenship, and all, then how they all fit in on parliamentary election. So because of I think there are about 2 or 3 parliamentary elections which are being challenged, not because of the election themselves, but because of qualification, right? That those who have been elected are not Ghanaians and all that. So I think that it will be helpful to be aware of this type of thing, because you never know, and that is why I find this question relevant. Yeah, Asinov. Yeah, that is the Asinov. Yeah, thank you, Anthony. Yeah, so that is very useful. And the Asinov, I think, decision, you have the judgment already. So those who do not have it, you can put it on the platform. Otherwise, I'll put it back on the platform. Just run your eyes through the Asinov decision, so that just like the Adamu Sakandi type of case, right? The Bibel case, which came up in the 2011, as it were. So let's keep our focus on that. Now, someone has sent me a question, which just one question on the WhatsApp, and I don't have the person sent me a question which borders on the fact that the Constitution is almost 30 years, and how far has the Constitution come? Are there areas that we may want to see some reforms and things like that? I'm just showing you the question in just a minute, and then I will direct you on what to do briefly, and then we move on. What we are trying to do is to waste too much time on any particular issue or question, but to move very fast so that we can cover different areas, since you are different people and you have different needs, right? So let's look at this. I just put it in my email because the person sent it on WhatsApp. So I just copied it and emailed it to myself. I don't know if you can see the screen. Can you see the screen? Can you see the cursor, where the cursor is moving? Can anybody confirm in the chat or something? Can you see the, okay, let me see. Okay, all right, thank you. Good, so this is the question the person sent. Ghana has been operating the 1992 Constitution, fourth Republican Constitution, for about 30 years. Several people have criticized it for creating an overly dominant executive arm of government. To what extent do you think the provision 1992 Constitution on the executive formed by the historical antecedents of the Constitution? Okay, this is what the person has said, but I would even create a number of possibilities around this theme, right? Yes, it is important that it's about what we call it the stock taking. The Constitution is 30 years. So in taking stock, do we think that the Constitution has served us well? We can have like a general question on that. And then what are problem areas, right? Which you would like to suggest reform. So that is one general thing. Then we can have specific questions similar to what this student has brought up. But here, I like the first part of the question, but like the second part, I think it's a bit different. But the first part, that the Constitution creates overly or excessively dominant executive. Do you share that view? If you share that view, do you think that it undermines constitutionalism or any of the principles of like good governance? And then what reforms would you like to suggest? Now, there's an overly dominant executive is one issue which came up during the Constitutional Review Commission. And some of the things that we talk about are the fact that if we take the kind of executive you have now, you have, like, of course, presidential system, but the president, who is the repository of executive authority, as we see from Article 57 thereabout. Yeah, so as we see from Article 57 and 58 read together, the president has also been given so many appointive or powers of appointment. So many things. Is the president who is supposed to appoint, who is supposed to appoint, who is supposed to appoint. So when we're even doing the review, some people did some mathematical computation. They said that effectively, if you're elected president of Ghana, you're supposed to appoint about 5,000 people, about 5,000. You know, the boss and other things put together and all that. And so the question is it a good idea for us to invest so much power in the presidency? Then even come to like the judiciary, Supreme Court judges, we have the president who will have to appoint them, other Superior Court judges like the Court of Appeal, the High Court, and all that. Despite the fact that he does so on advice of maybe the Judicial Council or on the Council of State and so on and so forth. But ultimately, he has the appointive power, and he has the power to fire, you know, to hire and fire. And all these are some of the things which have been coming up. So I think that is useful for us to think, but I will not waste time on this. But I tell you that if you go to, I think, either chapter 4 or so of the Constitutional Review Commission report, these matters have been solved there. So you don't need to reinvent the wheel. Just spend just about 1 hour or 45 minutes and run your eyes through. These matters have been worked out there, so you don't need to reinvent the wheel. You don't have to worry yourself about that. And then in relation to this, another thing that I will bring up is the fact that is in the area of like the Supreme Court, right? That is another area. I'm just trying to probably exhaust things about constitutional law I want to tell you, and then then we'll just be doing like going through like the past questions as we'll be doing. That is why I'm just running like that. So another area from constitutional law I would like you to think about is the the composition of Supreme Court, okay? Like the fact that there's no upper number, there's no capping. If you look at the Constitutional Review Commission, it was suggested that let's cap the Supreme Court at 15, so that at every point in time, the membership of the Supreme Court will not exceed 15. So I'd like you to think about the pros and the cons, right? What are the arguments for leaving the Supreme Court with no cap, and you can appoint as many justices as you want, so long as you have met like the minimum? And then what are the arguments against that, right? So think about that. So I think that is another thing from constitutional law that we have to be interested in thinking about. Okay, so I'll pause for 1 or 2 minutes and take some reactions from you before I move on. So if you want to, so just raise up your hand and then you are released. Whose hand is up? Let me see. Okay, you have the... Okay, if no hand is up, let me quickly conclude on this GIMPA questions, and then we can come back to some of the past questions themselves of the entrance examination. Okay, so I said that the question 13, the reason for bringing it to your attention is because of the 3 or 4 parliamentary election disputes which we have had, and about 3 of them center on qualification, right? And most of them have to do like the dual citizenship. So just remember that, just in case. Now let's look at the 12th. With the aid of decided, okay, Daniel.
Yeah, hello, sir, good evening.
Good evening.
Yeah. So my issue has to do with the question 11. I'm looking at, let's say, we are talking about dual citizenship, or maybe probably
No, I'm not.
as to establishment of whether the person.
Yes. Okay. Go ahead.
I'm
not saying that the question is dual citizenship necessarily.
Yeah, I just want to ask a question in respect of dual citizenship.
All right.
Good. And looking at Article 94, is it Article 92 or so,
okay,
which says that if a person owes allegiance to a different country, he's not qualified to be elected as a member of parliament. So I have an issue with the allegiance and citizenship. Looking at the oath of allegiance, so is it the same allegiance they are talking about under Article 92A? The oath of allegiance.
Okay, all right.
Or it's a different thing?
All right, thank you, Daniel. Okay, so we have the oath of allegiance, which is different. The oath of allegiance, I will bear true faith and allegiance to the Republic of Ghana by law established the sovereignty, integrity of Ghana, that I will preserve, protect, and defend the Constitution. Okay, so if you bear allegiance to a country other than Ghana, and the primary evidence of you bearing allegiance to another country or to a country is that you are a citizen. Because if you are a citizen of a country, the primary obligation is that you bear allegiance, right? You'll be loyal to that state. Allegiance simply means that you'll be loyal to the state, and you are not going to do anything which will let you undermine the state, in which case it will be treason. So we don't expect that a citizen will wage war against the particular state in which is a citizen. or he will collaborate with enemies of that state to attack it. These are all manifestations of you owing allegiance. So if you talk about you owing allegiance within Article 94, Clause 2, Paragraph A, that you owe allegiance to a country other than Ghana, we are not talking about the oath of allegiance that you subscribe, but the fact that your loyalty is to another country and not Ghana. I think that is my understanding, but I don't know what you take it to be. Has anybody got any comment on Daniel's question? Okay, otherwise we will take that as, okay, Saint Mugai. Saint Mugai, yes, you can unmute yourself. Yeah, I think he's gone. All right, so question 12, with the aid of decided cases and authorities, assess the provisions in the 1992 Constitution in respect of how a person or citizen may protect his or her fundamental human rights and freedom guaranteed under the Constitution. I think that this is a very straightforward question, which all of us should be able to do. As I always indicate, if you have a question, an essay question or composition, you must have like a clear structure. So you have an introduction doing what I have explained you're supposed to do already. So there's some of the relevant points which we need to remember. The mechanism for enforcement of the fundamental human rights. Remember Article 33, isn't it? Article 33, the fact that the High Court has been given original jurisdiction in enforcement of fundamental human rights. And of course, yeah, so I was making the point that in terms of the mechanism for enforcement of human rights, we have to be conversant with two main things. We have to be conversant with, first of all, enforcement through the court, right? Enforcement through the court. If you are talking about enforcement through the court, we have to remember the court which has got the original jurisdiction. Original jurisdiction, the Constitution has settled that. Article 33, we are told that this is the High Court, which has original jurisdiction. You read 33 with the Article 100 and excuse me. Yeah, you read in conjunction with Article 130. So 33 read with Article 130 because Article 130, when it's talking about the original jurisdiction of the Supreme Court, it makes it subject to the exclusive original jurisdiction of the High Court with respect to enforcement of what? Of fundamental human rights and freedoms embodied in Chapter 5 of the Constitution. Yeah, so that is what we have to remember. And of course, there are a number of cases in which there has been some seeming confusion as to whether the original jurisdiction of the Supreme Court, for example, conflicts with the jurisdiction of the High Court to enforce human rights, especially so when we are told in Article 2 of the Constitution that if anybody is alleging that anything is unconstitutional, it can go to Supreme Court and all that. Remember the case of Ibel Edusei versus the Attorney General, Tenadi versus Attorney General, so many cases in which the Supreme Court have had to actually make clear that its original jurisdiction to interpret and enforce the Constitution is different from enforcement of fundamental human rights. So if it is just about enforcement of fundamental human rights, you don't go to the Supreme Court. Yeah, so that is one thing that you have to remember. And again, if you are talking about that you can go to the High Court, that is not enough for you to finish answering the question. When you go to the High Court, what remedies are you looking for? the remedies which you can get for enforcement of your human rights through the courts are also stated in Article 33. The High Court may give a number of remedies, directions, or orders, including certiorari prohibition, habeas corpus, mandamus prohibition, and quo warranto. You know, even it can even give a injunction if it considers necessary for enforcement of human rights. So those are the remedies which one may get when you go to the High Court to enforce your human rights. So that is the one thing that we have to remember. And again, we also have to address the non-court one, right? Where you can enforce human rights not through the court. You can do that through CHRAJ. So we have to remember that another aspect of mechanism of enforcement of human rights is through Commission for Human Rights and Administrative Justice. So if you are doing this type of question and you talk only about the court, you wouldn't have done justice to the question. Okay, so we will leave that unless someone has a question on the 12th. Otherwise, we will quickly leave that and move on. Then recently, I mean, in relation to question 13, I will just draw your attention to this face the country thing, right, which is going on. Face the country, the demonstration, and all that. So we have to go back and read NPV versus Attorney General and also read the Public Order Act. I mean, once we look at this, we have material to be able to examine or assess whether what happened with respect to the attempt by the Face the Country to go on demonstration and what the police did. I'm talking about the constitutional dimensions, the legal dimension regarding the procession, right? Freedom to demonstrate, freedom to embark on procession and all that. And you have to always remember NPP against IGP, and also the Public Order Act as amended in 1994. I've seen some. Yeah, okay, so I think the Josephine, which cases? You mean Ibel, Edusei, Tenadi, and the rest, or which other cases you can specify so that we can provide them? Yeah, then the question over here, because it's lengthy, that is why I just skip it without reading like the entire program, but just to direct. Yeah, Barrister.
Yeah, thank you, Doc. I didn't get you clear, but it's like I heard you said a demonstration is one of the means or the non-court.
No, no.
I didn't get.
No, I didn't. I have moved away from that. I think for enforcement of human rights, I said that we have two main, we have two main avenues. We have the court and then the non-court. So the Barrister, I think there's a noise from your background. If you can take the noise. There's a noise from your side. All right, thank you.
Yeah, it's fake now.
All right. Okay. So for the court, I said that we have to discuss the jurisdiction of the High Court, remedies which are can be assessed and all that, right? Within the context of Article 33, 130, and so on. So that is the court. And then I cited some of the cases, especially where there has some sort of like a confusion between the jurisdiction of the Supreme Court to interpret the Constitution and also the jurisdiction of the High Court to enforce fundamental human rights. And I mentioned some of the earlier cases which came, in which the Supreme Court actually clarify what the position of the law is. Okay, so I mentioned the Aduse against the Tenadi case. You can even cite the recent the case of Ampia Ampofo against CHRAJ as well. There are a lot of cases, but these are like the direct one in which the court said that if you are just looking for enforcement of human rights, then despite the fact that the Supreme Court has, this was about like the passport, right? If you remember the passport case, and then the Sosudis, the exchange of, if you are just looking for enforcement of the human rights, then go to the High Court, right? So that was the point which was being made in that case. And then I also said that apart from the court, you can also go to CHRAJ, Commission for Human Rights and Administrative Justice. Because if you look at the provisions on Commission for Human Rights and Administrative Justice, their mandate include enforcement of fundamental rights, right? It includes enforcement of fundamental rights. So that is another avenue where a citizen can go to actually enforce his human rights as it were. Then apart from even CHRAJ, as per article, so if you look at article 218, just to give you an example, the function of the commission shall be defined and prescribed by act of Parliament, shall include A, to investigate complaints of violation of fundamental rights and freedoms. So enforcement of fundamental human rights is part of the work of CHRAJ, except that, as we know, where CHRAJ has given a decision, it does not have power of enforcement. It will need to go to the High Court and then get enforcement orders before it can enforce its decision. So that is one of the problems associated with CHRAJ, right? So if, for example, we also have to do a question on CHRAJ, maybe you ask to either assess CHRAJ and then what aspects of it are in need of reform and things like that. That is one thing that you have to also remember, that under the current constitutional arrangement, CHRAJ does not have power of enforcement. CHRAJ, you always have to go to the High Court and get orders before its final decision can be enforced. And that can actually make it unnecessarily long. If someone went to the High Court direct, he or she will be able to, you get a judgment, and then the judgment can be executed using the known processes of execution of judgment. And that is why in the Constitutional Review Commission report, it's been recommended that we should amend the Constitution and then give CHRAJ the power to be able to enforce its decision, as the High Court's decision can be enforced just like that. And quite apart from that, you also remember the famous Richard Danane, ex parte Richard Danane case, right? Involving CHRAJ concerning corruption investigation, where the court made the point that unless there has been a complaint, CHRAJ on its own cannot investigate allegations of corruption and all that. Now, if you look at the Constitutional Review Commission, it is also recommended that that is not necessary, that CHRAJ, the law should be amended so that CHRAJ on its own can so more to investigate any suspected instances of corruption, abuse of office and all that. So these are some of the things that we have to keep in mind. So I was not talking about the Public Order Act in relation to this. No, that is not it. And maybe finally, the other point in terms of the avenues for enforcement of human rights, which you have to also remember, has to do with what you call NMC, National Media Commission, right? National Media Commission. In terms of human rights related to press, like the press freedom and things like that, it's also human rights. We have the NMC there, National Media Commission. So that is another avenue where we can also get your right, as it were, enforced. Because they too have also got some powers to actually investigate allegations against the media houses and broadcasters, as it were. Yeah, so I just mentioned the public order case. So look at question 14. Critically appraise the decision in NPP against Attorney General. NPP against the IGP. 1993-94 to Ghana Law Report. David Ajay, just 1 second. The public order case and indicate the importance of this decision for promotion of human rights and constitutional government in Ghana. Yeah, so this, if you have a feeling that there could be a question because of the face the country thing, it will not be out of place for you to look at the NPP against IGP. If you remember, under the old public order decree, no budget had been read. NPP wanted to go on NPP was in opposition. It wanted to go on demonstration, and under the decree, you needed to get the prior approval of the police and all that. They applied, they didn't get it, so they decided to go. Then the police came to attack them, brutalize them and all that. Then eventually, they went to Supreme Court to seek interpretation that if you look at the provision of the Constitution in relation to freedom of demonstration, freedom of expression, and so on and so forth, you don't need the permission of anybody before you can demonstrate. Then the Supreme Court struck down aspects of the public order decree as being unconstitutional. And that actually paved way for the enactment of a new legislation called the Public Order Act of 1994. Yeah, David. David, you can unmute yourself, okay?
Okay, Doc. If you look at the decision in J. Ampofo, number 1,
okay,
versus Metropolitan Assembly and Attorney General 207-208, it made a very clear distinction that when it comes to, in terms of the fundamental human right and freedom,
yes,
the High Court has the jurisdiction under the Article 33 and 140. But the Supreme Court, however, in terms of human right, when it is in the public interest, then the Supreme Court has the jurisdiction. So it made a very key distinction that even though the High Court, that supervisory in terms of enforcement, 140, when it comes to public interest, such a person have to go to Supreme Court for the enforcement of such human rights. So in that case, it introduced a new concept that if the human right you are trying to enforce is of a public nature, public interest, then you have to come to the Supreme Court.
Okay. Now, okay. So thank you. So if you remember the J. Ampofo's case, I think that had to do with the latrine. Is that not the case? The nice soil, the carrying of the toilet. Is that not the one you're referring to? Ajay? Oh, it's lock himself again. Is that not the toilet, the latrine case you're referring to?
Yes, Doc. Yes, Doc.
Good. So if you tell like the latrine case, or the example against the EM, as you have rightly said, I think it was not just ordinary, it was not the enforcement of human rights. You see, when we talk about the enforcement of human rights, we are talking about where there is no dispute regarding the constitutional meaning of that particular right and so on and so forth. But the example for one, I think it was more invitation to interpret the certain aspect of the, not only the chapter 5, but also some provision from chapter 6 as well. And that was why the court made that distinction. But it does not take away from the constitutionally preserved original jurisdiction of the High Court with regards to enforcement of fundamental human rights. The Supreme Court does not have concurrent jurisdiction, no. So that if you are just talking about enforcement of fundamental, and you see, and don't forget that when it comes to enforcement of fundamental human rights, we have a term, there's a limitation of actions apply. If you look at the rules of procedure, where you are complaining of a violation of human rights, you have 6 months, isn't it? You have 6 months within which to bring your application from the time that you became aware of the violation, so that maybe limitation of actions can, for example, affect you. But when it comes to original jurisdiction, there's no time limit. Anytime that you wake up and you think that something is unconstitutional and so on, you can go to court. And that is why, yes, I think somebody hand is out. Jalin. Yes, sorry. Yes.
Thank you. Just to add, the Ajayan Pofu versus the AMA and the Attorney General.
Yes.
I think the issue there was they went under Article 22, then 130. The per AMS conduct of allowing people to carry 9 soil.
Yes.
It was dehumanizing the person, and to that is they went under 22 and then 130.
Right.
So it was an interpretation.
Yes.
For the court to rule on that. Thank you.
All right, thank you very much. Okay, so let's quickly move on. And I think we've looked at the 15 already, enforcement of human rights, and then changes that we like to make in either the structure or content of the 1992 Constitution. We've also discussed that many times today. Who is familiar with the decision in Nati and Gatti? Nati and Gatti. Okay, Daniel. And then Jacqueline.
Hello.
Yes, Nati and Gatti.
So nothing has to do with constitutional interpretation, and it's originated from a district court at Odumase Krobo, where Nati is a lawyer, and his client, he defended the defendant in this case, in a court case, and the defendant failed to pay his legal fees. So he took him on in the district court at Odumase Krobo. What happened was, if you read section 10 of the Act 32, the Legal Professions Act,
yes,
the lawyer is supposed to give his client a bill
of fees, yeah,
and for 1 month.
Okay.
Before and on expiration of the 1 month, if the client still refuses to pay the legal fees, then you can take him to court.
Okay.
But the plaintiff didn't observe this. For the recovery of his legal fees, the client put up the defense that you are supposed to give me a 1 month notice and a bill of the amount I'm owing you. And because you've not done that, you cannot bring an appeal to the court. You have to exhaust that remedy. What happened was, Nati put up a constitutional issue at the district court that particular argument the guy is raising is an affront to Article 17 of the 1992 Constitution. And it is discriminatory because if anybody at all is owing me, you don't ask me to give the person 1 month notice. Why should I give my client 1 month notice? So it is discriminatory, giving different treatment to the same people. The case went to the court. Benin JSC sitting on the matter. So the issue that was decided was as to whether or not that particular provision in Article 32 was an affront to Article 17 of the 1992 Constitution.
Discrimination clause. Okay.
The discrimination clause. Can I continue, sir?
Yes, continue. Continue.
Okay, so Benin JSC ruling on the matter stated that the Article 17(1)
Daniel, are you there?
Has to be read.
Is it from my internet or your internet?
Together with so can I go on?
Yeah, sorry. Yes, my line went off. I'm back. Yes, please.
Oh, okay. So Benning JSC was of the view that Article 17.1 has to be read in conjunction together with Article 17.2 and 3. And Article 17.2, anybody who nobody shall be discriminated against on the grounds of gender, race, creed, religion, and all those areas enunciated in the Constitution. And it's of the view that if anybody is discriminated on those grounds, then the discrimination is unlawful. But if anybody is discriminated on any other ground apart from those grounds that were enumerated under Article 17.2 and 3, then the discrimination
The then is gone off. My line is going off.
for applying. In that case, they also applauded the district.
Yeah, sorry, I'm back. Okay, they applauded who? Sorry. Yeah, sorry, my internet is just rough. Sorry. Daniel, are you done?
I was saying that. So the Supreme Court held that the article section 10 of the Art 32 was not inconsistent with Article 17 of the Constitution.
Right. Okay. All right. Thank you very much. I think that that is a very good account as far as that case is concerned. I wanted us to move on, but I noticed. Okay, so Daniel, Ella would like you to type the case, the Gatti. And of course, that case, too, because it discusses discrimination, is also relevant when we are thinking about the LGBTI type of question. And the material I sent you, the one I sent you from the Canadian, that research paper, you notice that they have cited Gatti, right? In trying, Nati and Gatti, in trying to explain discrimination, so that if you want to argue whether our laws, as they are now, they discriminate against the so-called, those who profess LGBT, then you have the proper compass to guide your reasoning. So that is one thing that we have to keep in mind. Yeah, so we will, I think the constitutional law has taken all our time. So let's do one quick, let's look at the 2018 questions, right? Daniel, is your hand still up? Daniel, is your hand still up? Okay, okay, it's gone, okay. Okay, it's gone. Now, so if you look at that, these are what we call like the 2018 questions. That's about 2-3 years ago. So we will try and look at all of them quickly, and then we are done. So question 1, in exercising his prerogative of mercy, the president acts on, and of course, the prerogative of mercy, you remember the case between Eli Plim, Avemava, and 2 others against the Attorney General. Now, I happen to be the lawyer for Eli Plim, Avemava. That case is also very useful in trying to understand how the Supreme Court interpreted the scope of discretionary power, right? If you look at the Article 296 of the Constitution, which governs exercise of discretionary power, my client, Mr. Eli Plim, my client, who is also my classmate, Mr. Eli Plim of course, who also wanted to contest Mr. John Mahama for the NDC slot. I hope that in future you will get it, but that was just for another day. So he was concerned following the Muntie case. Remember the Muntie case? Those journalists who were cited for contempt by the Supreme Court for unprintable comments that they made against the Supreme Court, the former Chief Justice and all that. And when they were put in, the president at the time, His Excellency Mr. Mahama, gave them reprieve, or what they call it, the presidential pardon, in exercising the prerogative of mercy. So some Ghanaians, including my clients, were worried as to whether the power to grant prerogative of mercy, whether that power involved discretionary power. And if it involved discretionary power, then what it means is that discretionary power had to be governed by Article 296. You know that Article 296 of the Constitution actually provides a framework for how you can actually how you can properly exercise discretionary power, and you will not be accused of having been arbitrarily or having improperly exercised that power. So the argument was the power of the president under Article 72, right? If we take Article 72, which governs prerogative of mercy, that the president may, acting in consultation with the Council of State, A, grant to a person convicted of an offense a pardon, either free or subject to lawful conditions, or B, grant to a person a respite, either indefinite or for a specified period, from the execution of punishment imposed on him for an offense, or C, substitute a less severe form of punishment for punishment imposed on a person for an offense, or D, remit the whole or part of the punishment imposed on a person or for penalty of which otherwise due to government on account of any offense. Good. So the point which had been contested as to whether the power of the president to do any of the following, right? Does it involve exercise of discretionary power? If it involves exercise of discretionary power, if you go to Article 296 of the Constitution, which the sessional note or the marginal note says exercise of discretionary power. And it says that where in this Constitution or in any other law, discretionary power is vested in any person or authority, you have to follow it. It requires that you have to be candid, fair, you have to avoid arbitrariness. And then if you are not a judge or if you are not a endowed with judicial power, then we are supposed to come out with predetermined rules which will govern the exercise of that discretionary power. Remember the case of the captain, right? Remember the case of the captain versus like the Minister of the Interior, as well as the France versus the Attorney General and all that on discretionary power. So that was the question in early prelim against Attorney General. But the Supreme Court concluded that, yes, the power of the president to exercise prerogative of mercy involves discretionary power, but it is not the type of discretionary power which is amenable to the controlling mechanism of Article 296. So the Supreme Court was telling us that it's not all discretionary power, vested in the president or an entity, which will necessarily have to be subjected to coming out with like the predetermined rules and so on. Yeah. So let's come back to the question before us. In exercising his prerogative of mercy, the president acts A, on advice of the cabinet, B, in consultation with Parliament, C, in consultation with the Prison Service Council, D, in consultation with the Council of State. As I read Article 72, the opening clause says that in consultation with the Council of State. And that is why I have been advising you over 1 month or 1.5 months ago that you should be reading the Constitution. Like this type of question, if you've not read the Constitution and you don't know that it has to act on the advice of the, in consultation with the Council of State, you may go wrong, right? So let's pay attention to the reading. Yeah, so the answer is D. Or has anybody got a contrary position? In which case you can let us know. Okay, so let's come back to question 2. Contracts which cannot be made. Contracts which cannot be made orally and requires writing in the Contracts Act 1962, Act 25 include A, guarantee, credit or character of third parties and sale of goods. B, of course, when you read A, one thing you have to know that you see sale of goods, right? Sale of goods is not, expressly governed by Act 25, as it were. So you have to, just ignore that. And sale of goods can be by word of mouth. It doesn't have to be in writing. So by elimination method, you know that question A cannot be the answer. Although, if you take A, which is like the guarantee, right? Contract of guarantee must always be in writing. If we look at the Acts, what do you call it, 25. If we look at Act 25, contract of guarantee must be in writing. Otherwise, you will run into difficulty in terms of enforcement. B, guarantee, land and credits and character of third parties to acquire goods or credits. Yeah, that is also quite vague. If you say like, yeah, guarantee, there's no program by guarantee. So you know that definitely guarantee must be in the answer. But there's some of the other things which are added are supposed to be red herring, or they're supposed to be irrelevant. So B, you dismiss it because it doesn't make sense. If you say guarantee, land and credit, character of third parties to acquire goods or credit. How do you need the character of a third party to acquire goods or credit? Isn't it guaranteed that we need a person to grant? And if it's a guarantee, then it has to be in writing, isn't it? Then C, guarantee, land purchase and loan. Yes, C appears to be high candidate, but let us test correctness of C. against D. The reason why I'm saying that C appears to be a good candidate, of course, appears to be a good candidate is the fact that the mention of guarantee is there, the loan, and then the land purchase. But I must say that the person who set the question, the answers, some of are contestable, isn't it? Because if you're talking about contract, which cannot be made orally and requires writing. Yes, land, contract, involving sale of land. Of course, if you need what they call we have exception, isn't it? You have exception if it's less than 3 years. If you look at the old conveyancing decree, and if you now the new Lands Act, if it's less than 3 years, in appropriate cases, it can be oral, can be by word of mouth, and that will be valid. And even if it's also like customarily, so why will you say that writing is a mandatory? So that is problematic. Then loan to need not, but when it comes to what we call the written acknowledgement of debt under the Limitations Act or decree, then because the written acknowledgement of debt, then the writing becomes, if you like, the mandatory. Now let's look at the D, guarantee, sale of goods and land purchase. Sale of goods, as we know, does not have to be in writing. If you look at even like the Sale of Goods Act, in any case, it's the Sale of Goods Act which governs sale of goods mainly. Of course, there are some other relevant provisions in the Act 25 concerning sale of goods, no doubt about that. But sale of goods, we know does not have to be in writing, so that cannot be the answer. Land purchase, as I said, it can be, it also need not be. So under the circumstances, you notice that, but let's look at the I don't know if anybody has got like the Contract Act. The contract, because what I have been doing is to use the elimination method to help you to get the right answer. But let's look at the provision itself. Provision of the Contract Act. Yes, Barrister. Barrister, you can unmute yourself, please.
Yes, though I have the act with me.
So read the provision for us so that we have the direct provision. Because what we'll be doing is just to use what we call like the convenient elimination method. Okay. We need to get a provision itself. Yes, section.
I think section 14. It starts from section 14. Section 14, 1 and 2. And then if I may read it.
Yes, please.
Okay. So section 14.1, it says that any agreements made before or after the commencement of this act, whereby a person hereinafter referred to as guarantor guarantees the due payment of a debt or the due performer of any other obligation by a third party shall be void unless it is in writing and is signed by the guarantor or his agent. Or is entered into the form recognized by customary law. Then 2, any person or representation, any promise or representation made after the commencement of this act relating to the character or credits of any third person, with the intent that that third person may obtain credit, money, or goods from the person to whom the promise or representation is made, shall be void unless it is in writing and is signed by the party to be charged therewith or his agent.
So the B becomes like the correct answer according to the provision.
Yes.
B.
Yes. Because it contains the character of a third party to obtain credit and those ones. And I think the argument is now around the land. And since we have land in both option B and C, so I think it will be safe to settle on
B will be safe. But the other one is only that the except customary what? Is it? I heard something about customary law.
Entered into a form recognized by a customary law.
So that's also suggests that Because customary law does not know writing, isn't it? It does not know writing, but
Yes.
as I said, for multiple choice, we go for what we call like the most suitable answer. So the most suitable answer and the circumstances. That's why the fact that the customary law bit makes it contentious as whether the writing is really, really mandatory, since customary law does not know writing. But the most closest answer will be B, because at least it contains most of the elements which are stated in that provision that you read. I don't know if you have some contrary view. Does anybody disagree? Okay. Then let's move on to 3. But Barrister, if you are there, let's use that opportunity to. Okay, he's gone. Okay, but at least, please, all of us, let's look at section 14. Okay, section 14. That is guarantees to be in writing. These are just limited transactions in which writing is made mandatory. So let us know that. So let's look at the section 14. 3. Under what conditions may a person be exempted from criminal liability? I think we've discussed this type of question before. I think the other one we talk about the dolus incapaz and all that. Okay, so insanity. It's an insanity. Insanity is a defense. Okay. Alibi saying that you were not there when the crime was committed. Mistake and drunkenness. Let's test it against the rest, because we see infancy, dolus incapaz there. So intoxication. If someone is intoxicated, it doesn't mean that he's exempted from criminal liability. Some other things will have to be present before you could get it as some form of like a defense, isn't it? Alibi means that you're not there when the offense was committed. Infancy, yes, dolus or incapaz dolus, that is you're below the age of 12 years. At the age of criminal responsibility. Apology. If you simply say that you are sorry, that does not exempt you from criminal liability, because apology will come after you have been found guilty. But that will not exempt you from criminal liability. C. Infancy. Insanity, mistake, and apology. So since we have like the apology in B and C, I think that will disqualify B and C. Since, at least we know, how can somebody simply say that I'm sorry and then you are just exempted from criminal liability? We even have something we call like you can be reprimanded or cautioned instead of you being given any major sentence, but then you have been found criminally liable. And that is why the apology is only going to extenuate or reduce, if you like, the sanction that the judge may want to give to you, but doesn't mean that you're going to be exculpated from liability, as it were. So therefore, the good candidates for answer will be between A and D, because for B and C, I think the elimination method can help us to, because of the apology there, unless someone disagrees, but I think that the apology there makes B and C actually bad candidates. So you are left with the A and D. So let's take D. Insanity. And last time I asked you about the Magnetan rules, and you didn't speak to me about that. Okay, and a number of you have put down some stuff. Okay, good. So somebody has put the whole provision there. Okay, that is good. Question 3, okay. Insanity, infancy. Yeah, as for infancy, we know that infancy 12 years. So that will make it easier for us to prefer D over A. Because as I said, alibi does not really, alibi, you are saying that yes, you are not the one the crime was committed. So that one is not important, but the infancy, which is there. So infancy, insanity, intoxication, and mistake. Although there are some other things which will have to be established before any of this intoxication, mistake, and insanity can actually exempt you from criminal liability. But at least the fact that we have the infancy there makes it comfortable that D is the best answer rather than A. Or does anybody have some comment or contrary opinion regarding D being a better option than A? And as for B and C, there will be no dispute regarding its wrongness. Okay, and let's look at 4. It has been suggested that judiciary has a function of acting as officially constituted representative of the collective conscience of society. And it is desirable that if only in exceptional cases, they shall have the power to declare certain actions criminal. Okay, so that is a statement. Choose from the following statements the demand which in your view, the above suggestion runs counter to. So which of the following statements undermine or is not in agreement with the statement that we have made? A, crimes ought to be dealt with expeditiously in order to preserve order in society. Okay, it makes sense, isn't it? Okay, let's move on. B, judges are, and of course, remember that we said that justice delayed is justice or denied, isn't it? Justice delayed is justice denied. So, and if someone is arrested, charged with a crime and all that, he will need to know his fate as whether he is guilty or not, so that his liberty can properly be restored to him. So I think that A is in agreement with the statement. So A is not the answer, because we are supposed to pick a statement which is not in agreement with the quotation over there regarding the function of judiciary vis-a-vis criminal cases. B, judges are appointed officials and are in practice not accountable to the electorates. Their function is to adjudicate and not to make laws. Okay, let's flag that, but let's move on. So let's flag B and move on. Yes, of course, judges are appointed and they are not directly accountable to electorate, but there are processes by which they are held accountable: supervisory, jurisdiction, appellate, other discipline, and so on. So their function is to adjudicate, not to make laws. Then that is true. C, as a result of long procedures, they must pass through in Parliament before they become law. Statutes are outpaced by emerging crimes. Okay, and that is true, because we say that human behavior is always ahead of the law, and that is true. There are a lot of things going on which are not right and we need to be legislated, but they've not been legislated. But the other thing also is that we cannot call anything a crime under the Constitution. If you look at Article 19, right? I think we take Article 19, I think the clause 11, that no one shall be punished of a crime unless same has been defined in a written law with the punishment. Yeah, no person shall be committed of a crime, no offense, unless the offense is defined in the penalty for it is prescribed in a written law. So if the thing has not been legislated as a crime, then under our Constitution, it's not a crime, isn't it? So if you say that statutes are outpaced by emerging crimes, if you wanted to be very critical, we say that that is a wrong statement, because if the thing has not been passed in the form of legislation, according to Article 19, Clause 11, nothing is a crime unless it has been defined in a written law with the punishment prescribed for it. Then it's not a crime. But let's hold on and move on to D. The reality ought to be faced that all along, as they interpret and apply statutes, judges are making laws. This trend ought to be acknowledged and encouraged in this era of proliferation of crimes. Okay, so which of the following statements run counter to the position that the judiciary has the function of acting as officially considered representative of the collective conscience of society, and that it is desirable that if only in exceptional cases, they shall have power to declare certain actions criminal. Now, I've told you Article 19, Clause 11, which says that nothing is crime unless same shall be what? Declared in a written law with punishment prescribed. The only exception is when we are talking about contempt. Contempt of court is the only thing which does not need to be defined. One type of contempt of court is that which need not be defined in a written law, and the court can just punish someone for that. So therefore, which of the four statements that we have gone through you think is the correct one? Correct one in the sense that it is not in agreement with what we have stated. So the reality to be faced that all along, as they interpret and apply statute, judges are making laws. This trend ought to be acknowledged and encouraged in this era of proliferation of crimes. But the judges cannot create a new crime on their own, apart from contempt, which is a common law position and which is also recognized by the Constitution. So that is not that is not so. But of course, maybe if they have like the power to declare certain actions criminal, what they have the power to declare criminal will be contempt, because what amounts to contempt is something what the judges will have to determine as and when the behavior is put up. So in that respect, one will agree that yes, in exceptional case, and that those exceptional cases, as I said, the contempt of court is something is put up, just like the munti and so on. Then the court itself will make a decision as whether that behavior is a criminal behavior undermining the authority of the court, administration of justice and all that. So that one is true. So I would say that, of course, so D is reinforcing the statement, isn't it? D is reinforcing the quotation. Or what do you think? Then let's take C. As a result of long procedure, they must pass through in Parliament before they become law. Statutes are outpaced by emerging crimes. C. Now, as I said, C is problematic, especially if you put C in the context of what the Constitution says a crime is. Because if something is not a crime, apart from, let's say, contempt of case, contempt of court, if it has been defined in a written law or the punishment prescribed for it, then on what basis do you say that statutes are outpaced by emerging crimes? Or maybe unless the crime have been put in court. Yes, but I don't think that maybe the examiner's mind went to Article 1911 in the sense that, but if we wanted to be very strict, Article 19 tells us that there's no crime unless they have been defined in a written law. So in that case, how can you say that the crimes are multiplying faster than we make laws? So statutes are outpaced by emerging crimes. B, judges are appointed officials and presidents. Their function is to adjudicate and not to make laws. Yes, B, you think that the B run counter to the statement that in exceptional cases, judges should have power to declare certain actions criminal. I think B is a good candidate, isn't it? Because as I said, in exceptional cases, the judges should have power to declare certain actions criminal. Definitely applies to contempt of court. So apart from contempt of court, they cannot declare any other thing criminal unless it's defined in a written law. So if you take B, right? B says that judges are appointed officials and are in practice not accountable to electorates. So their function is to adjudicate and not to make laws. So that's, in a sense, if they don't have the power to make laws, then if something has not been defined in a written law as a crime, on what basis can they punish someone for that? And when it comes to contempt of court is like it where the judges themselves have, if you like, defined what the crime is, and then they also prescribe what they say the appropriate punishment is for that crime. So therefore, one will say that B is running a counter to the observation over there. What do you think? So I think that B appear, in my view, is the statement which runs counter to the quotation based upon the explanation and analysis that we have done. Has anybody got like a contrary view? Yes, you chose B, but like, are you convinced it's B? I just don't want you to just take the B. You must be able to justify your answer. Umar. Okay, so FJ. Yes, go ahead.
Okay. If they are not, if they can declare contempt, okay, it means that they have rules governing that, and that can be like a law. Okay, but the B is saying that they are just to adjudicate, they are not to make laws. So that's why I went for B.
All right. Okay. Thank you. So let's move. Let's look at 5. It stands to reason that an artificial legal person cannot be convicted of certain offenses. So artificial legal person, remember company law, Solomon and Solomon, Mokwa and Kuma. So corporate bodies or aggregate, corporate aggregate or corporate soul. Those are what you mean by like the artificial legal personality. And when we say the corporate, we are not doing company law, but corporate aggregate, we are referring to like the incorporated company and associations and all that, incorporated ones. And then the corporate soul, we are referring to just an office, which will be given the status of like a legal personality, maybe like the office of the bishop, or even like like the position of like the chief, as it were. Okay, so A, the nature of offense committed by the company. Is that the reason why a judicial legal personality cannot be convicted of certain offenses? Not necessarily, but let's flag that and move on. B, the impossibility of executing the punishment. No, that one is absolutely no, because of course, well, if you say impossible, if you say certain offenses, yeah, you are right, because let's say that can you convict a company of like a murder? You cannot convict a company of a murder. You can convict a company of a manslaughter. And if you have to, for example, imprison, are you going to imprison the directors, or you're going to imprison the particular officers who committed? No, it will have to be like a fine. So in that case, it is true that certain offenses you cannot artificial legal person C, the size of the company. No, that is not correct. D, artificial nature of the entity. No, that is not. So the right answer will compete between A and B. The nature of the offense committed by the company and the impossibility of executing that punishment. But I will say that the impossibility of executing the punishment is, let's say capital punishment. Can you impose the capital punishment on the company? Certainly not. When it comes to, let's say, even custodial sentence, can you impose custodial sentence on the company?
Yeah.
Unless you are prepared to lift the.
I was working and I was hearing.
Please, FJ.
I was working, I was hearing.
Can you actually mute yourself? FJ, can you?
Where
Good. Yeah. So if you. Yeah. So unless you are lifting the corporate, otherwise you cannot imprison directors and other things, isn't it? That's so I would say that. Yes, barrister.
Thank you, Doc. So you see, sometimes the way they provide the options,
yeah, it's very
usually doesn't, because I find it difficult looking or distinguishing between the option A and B. Because if you and the nature of a particular offense, you know, the offense and the sentencing usually they have some kind of relationship.
No, barrister. As for that one, I wouldn't say that. Because the nature of offense is the sentence is the punishment, isn't it? So
yes, Doc. I realize that it will depend on that's why we classify offenses. Okay, we have classification of offenses. So by the very nature of how a particular offense is classified, that will, come with a punishment, just like you mentioned, capital offenses,
misdemeanor, and things like that. Okay.
So it seems like the nature of the particular offense or how it is classified to some extent determines the associated punishment. That is what I was saying, like there seems to be some kind of relation between a particular offense by its nature and that's of the
So fine. I get where you are trying to come from. So in that case, you want to dismiss A and B, and then you want to focus on C as answer or D as answer. Barrister. Oh, I think we've lost him. Okay, but Emmanuel is here, so let me release Emmanuel. Emmanuel, Zaika.
They both qualify to have been, answers. Each of them could be an answer.
Which one?
So, yeah, between A and B, I think, even though the question is related to company law, because if it is a capital offense.
For A, I don't have, you remember the principle of attribution. We're not doing company law, but the doctrine of attribution,
yes.
Right? The doctrine of attribution,
lifting the veil.
Not lifting the veil. The doctrine of attribution can easily let us take care of A. So the nature of offense does not matter. The company functions through instrumentality of flesh and blood, through officers, directors, and all that, isn't it? So mens rea and so on, in appropriate cases, you can attribute it to those who are working for the company. But when it comes to like the punishment, are you going to let the officers serve the punishment for the company? Unless you have lifted the corporate veil, isn't it? But there are other hands up, so let's take other contributors. So Ella, and after Ella, Samuel, and then Emmanuel. No, I think Emmanuel has been, but I asked him to unmute. He didn't unmute. Emmanuel. Yeah, Emmanuel.
Hello, Doc.
Yes.
Well, I want to attempt it I chose B based on this. If you look at the construction of the sentence,
Yes.
it is talking about that it stands to reason that an artificial legal personality cannot be convicted.
Yes.
So perhaps maybe if it was talking about cannot be charged with certain offenses, maybe A would have been, but once it's talking about conviction, then you are already looking at punishment there. And so that's what is making my choice of B.
Okay. All right. So that's your logic. Okay. The answer is B, but I just wanted to get other arguments that you have. Yeah. So let's take Samuel. Samuel.
Sorry.
Yes.
Doc, I was thinking about D.
D. The
D.
nature of the entity.
Yeah, the artificial nature of the entity. Because I was thinking it's because of the artificial nature of the entity. That is why that makes it difficult for the offense. That makes it impossible for executing a punishment against them. So if we go for option B, because of the artificial nature of the entity, it makes it impossible to execute that punishment against them.
Okay, don't hang up, Samuel. But let's take this. I see what they call the secularity, right? What they call the fallacy of secularity in that way. Because if you say there stands reason that an artificial legal person right away means that it has artificial nature, isn't it?
Yes, sir.
Artificial legal personality means that it has artificial legal nature, or it has a juristic nature. And that is why I am not readily persuaded by D. But I'm interested to take further arguments that you have on that. I don't know if you get my point, because like do you understand the point I'm trying to make?
Yes.
Because I see that artificial legal personality means that the entity is artificial. So won't it be like we going around? Okay, Ella, let's give Ella the opportunity. Ella.
And Doc, please, this is just a humble suggestion.
Yes,
since we are not doing company law, I think we should just keep the question and not argue further. Thank you.
Oh, no, Ella, don't hang up. Ella. Ella, don't hang up. It's not company law. This is a criminal law. Let me get my criminal offenses tag. There's a provision, right? Let me get my.
Oh, okay.
It's a criminal law. It's not company law.
Criminal law.
Yes.
Please.
Oh, if it's company law, I will tell you. Okay. I'm a teacher of company law. So when I say company law, I know it. I will tell you, I won't waste your time on company law, but it's a criminal law. So Ella, I would like to take your thoughts since it's criminal law.
Okay, initially I chose B because of I chose B because of the wording used in the question that concerning offenses, as one guy mentioned earlier.
Yes. That's. I'm interested. Ella. There's a provision in the criminal offenses that I'm trying to pull that for you. That's what. When it comes to companies or corporation, there's a certain provision which I'm trying to pull for you. Anyway, when I find it, I will send it to you. Yeah. I when it comes to the, that will be in the chapter 2. Or no, like let's look at company and its officers, right? Let's go to company and its officers, the very beginning of the Criminal Offences Act. So let's take the opportunity to look at the company and its officer. That is the section 2. If you look at section 2 of the Criminal Offences Act, right, it's headed company and its officers. Let me quote it. A company includes a partnership or an association, whether corporate or unincorporated, whether the purposes are not carrying on a trade, and whether it is in the course of formation. Okay, so that is the general term what the company is. Okay. I mean, it doesn't really provide what we are looking for, but just explain what the company is for purposes of criminal law when a reference is made to the company. But I think that, yes, Samuel's there. You want to say something? Okay, I think there's I think let's move on. Let's move on. Sanam is not a company law, it's criminal law. I remove on. So at least I did not hear any other convincing argument than what we have. So I think that the B is the most suitable answer under the circumstances. So which of the, yes, Sanam. Sanam.
Most of the past questions. Sir, please, can you hear me?
Yes, Sanam. Is that Mr.? Okay.
Hello, sir.
Yes, please go ahead.
Okay, most of the past questions with regards to the same question, they actually take D, so I'm just confused.
No, if you so if you say D, I want the explanation. That's why I tell you that I'm not interested in the answers, which I'm interested in the explanation. So
Yes,
somebody attempted explaining, and I drew his attention to the fact that if you look at it, it's time to reason.
I get your explanation. I get your explanation.
So that's my.
Thank you, sir.
All right. Okay, so says which of the following amounts to dishonest appropriation? I think this is something that all of you can explain to me. So I'm going to take some of you to do the analysis on me this time. Yeah, so can I just read about the offense of stealing, dishonest appropriation? Yeah, can anybody summarize the position of the law for us? Can anybody summarize it for us with respect to dishonest before we look at the answers? Okay, Samuel. Samuel, your hand is up. Go ahead.
No, then it's a mistake.
No, but it's not a mistake. Dishonest appropriation, tell us. Okay.
So, sir?
Yes, please go ahead. Okay, I think you've got someone to bail you out, Emmanuel.
Okay.
Oh, no, he's gone. So, okay, Daniel is here. And then another person, W.
Hello, sir. Hello, sir. Hello, sir. So I think dishonest appropriation has to do with section 120 of the Criminal and Other Offences Act at 29. And it says that when a person dishonestly appropriates a thing, if he appropriates a thing, if he carries or deals with a thing with the intent to defraud or without a claim of right, what basically it means is that, and we can also get the meaning of the intent to defraud under section 16 of the Act 29, which says that an intent to defraud means a person causes a gain, which that gain can be measured in monetary terms, and that gain can become a loss to another person, then that person has an intent to defraud. With the claims of right, So if you deal with the thing, or you carry the thing in a way which you have the intent to cause a gain to yourself, and that gain can be measured in monetary terms, and that gain can become a loss or an expense to another person, then you have dishonestly appropriated that thing. There are other, I think, simplified.
Doc, you've muted yourself.
Okay, thank you, Daniel. Yeah, so if the appropriation is made with intent to defraud and without the owner's consent, is that dishonest appropriation? Daniel?
Hello, sir.
Is that dishonest appropriation?
Sir, come again. The question again.
A, is A dishonest appropriation?
Per the question, if appropriation is made with intent to defraud and without a claim, without the owner's consent, no, it is not.
Why not?
Because it's supposed to be two elements. One, intent to defraud, and two, without a claim of right. The A doesn't have the other element, without a claim of right.
But you remember section 121A is disjunctive, isn't it? It's not conjunctive.
Section
121A is disjunctive. We have all, not conjunctive, isn't it?
Yes, sir.
Yeah, so don't unless there has been a case law which you will cite to buttress your argument that it's conjunctive. Otherwise, the clear provision is disjunctive, which is all. So if it's made with intent to defraud, that will amount to dishonest appropriation. But let's move on. B, if the appropriation is made without a claim of right, is that it?
Yes, I will go for this.
You go for that. That one is 120B. 120B. If it is made by a person without claim of right, and if
I'll go for this one too. I'll go for this one too. I'll go for this one too.
Then you go for so many things, though, Daniel.
So let's go to the C. Let's go to the C. Let's do elimination.
All right,
elimination method.
You see, if the appropriation is made with intent to defraud, or by a person without claim of right, with the knowledge or belief that it is without consent of the owner or his trustee, or if known to the owner or his trustee, but without.
So I'm not going anywhere again. I like this one. I'm not going anywhere again.
Why do you like that one?
Because this one, everything. Yeah, this one seems to have everything. And if you look at the wording under it, it says that even if you dishonestly appropriate the thing, and the thing is maybe
we see,
person who has possession of the trustee.
Yeah, so Daniel, you see the C has merged two provisions under 120, or the A and B.
Exactly.
And it does not use the conjunctive as we wanted us to see. It uses the disjunctive. So just put everything together. So that is why we need to be careful. Let's say that if you just read the first one alone, but let's, Daniel, are you sure about C? Are you sure about C?
Yes, sir.
What is your basis?
So I'm sure about C.
What is your basis?
So my basis is Article 120, or I said Article Section 120.
Okay, 120.
Section 121.
All right. Okay, that's fine. So that settles it. That's true. Okay, so C is the answer. 7. Is there any difference between assault and battery? If yes, what is the difference? And if no, what are they? Okay, so there is a two-in-one question, isn't it? You need to, first of all, answer to yourself before you even start looking through the answer, whether battery and assault, they are different or they are not different. Obviously, if we are talking about law of tort, we know what they are, isn't it? But let's go through. And the question has not also necessarily indicated, but at least as we go through, we will find it. A. No, but before we move on, we need two contributors. Josephine, Josephine, your hand is up. Come again, and then another person here. We want somebody to summarize the principles relating to battery and then assault. And then assault and battery, yes. Josephine.
Okay. Yes, dog. Hello.
Josephine, I can hear you.
Okay, please. When it comes to assault, it's actually an intentional tort which has no application of force. But with a battery, it requires the application of force for it to take place. So that's the difference. One, with the assault, there's no application of force, intentional application of force in terms of the battery.
Okay. All right. I think yes, there's another person. The person has no name. Yes, you can mute yourself. You can mute yourself. Please, your hand has been up a long time. You can mute yourself. The person. Okay, so you remember session 84? Unless if you are talking about like the criminal law, isn't it? And we have like the assault and battery. We have assault without actual battery, and then the imprisonment. So let's look at the options. A, no. That is trying to say that there's no difference between assault and battery. No, there's no difference between the two. They all constitute physical attack on the person of another. Is that the case? Certainly not. B. So A, someone using the elimination method, A will not be the answer, isn't it? B. Yes, there's a difference. Assault is insulting words against another, while battery constitute physical attack on another. Okay, so let's flag that as a good candidate, but we haven't finished. We need to test the correctness or wrongness of it by looking at the remaining two. Yes, there's a difference. Assault is seeking threats of violence and exhibiting an intention to execute the threats, whilst battery is intentional application of force to another by direct means. Yeah, so C makes a B a bad candidate, isn't it? So now you've succeeded in weeding out A and B. D. Yes, there is difference. Assault is issuing threats of violence, exhibiting an intention to execute the threat, occupied with ability to carry the threat into execution, whilst battery is a deliberate, intentional, or negligent act of a person resulting in physical or violent contact with another, or that is concerned. So D becomes like the most perfect distinction.
Answer.
Yeah, so we see how the elimination method enables you to do what we call the graduated assessment of the quality of the answers. As you get one, don't just jump to it as a correct one. You have to keep evaluating it against the remaining options. So please, if you are, and that is why I know that all the past questions are there. People have answered them, circled them A, B, C, D, and all that. And most of you have all those, and that is fine. But that is not what is important to me. What is important to me is that you understand what is in the question. And then if the answer is, let's say, really D, you need to understand and appreciate why that is. The reason being that there's no guarantee that that same question is going to be repeated, but there could be something similar. So if you understand it, then even if you don't think of the same question, you'll be able to point out the answer. Or your examiner can take, let's say, the same question as 2018 and then change the answers. That's another way of examining. The same question, but you can change the answers, right? So if you change the answers, the student who has been reading the past question, you see the question and you say that I know this. You just go and put the letter there, and that will be wrong because the answers have been modified, isn't it? So even when you get the answer, still read through, please. Okay, Jacob, hand is up. Jacob.
Hello, good evening, Doc. Good evening, Doc.
Good evening, Jacob.
Yes. Doc, I'm just curious, if you look at section 84.
84, okay.
84. And then up to 86,
okay.
Talking about assault and battery.
Right.
Assuming you have a problem question, and I don't know whether you're going to treat it, and there's no, the examiner didn't specify whether this is tort or criminal. So which one are you going to treat?
It's a criminal law, so.
Because we have 84 here and 86.
Okay, right.
87.
Yeah, understand what you are saying. And quite frankly, these are some of the challenges. But if it's a problem-based question, to answer Jacob's concern, if it's a problem-based question, all right, if the question did not specify, and the question says that, for example, identify whether someone has liability in law, or whether someone, whether someone has any liability in law or the legal issues involved. Since you are writing a composite law paper, right? You could both. For example, raise the criminal law aspect, and then when you are done, you can do the tort aspect, or you do the tort aspect, and then when you are done, do the criminal law aspects. Because when the marking scheme is done, talking to some of the examiners, what I get from them is that when the marking scheme is done, the marking scheme is actually structured in the marking scheme is fair. It's very mindful of this particular issue that we are talking about. So it makes room for that. So apart from, if you like, even if, let's assume, if the examiner intended, let's say, criminal law, right? The marking scheme will make a room that if the student raised any other justifiable legal issue and is well discussed, the student should be given this mark. So that one is also there. Yeah, so that is what I can share for the time being. So let's go to Barry. Yes.
Yeah, to add up, if you look at the trend of the question in the past, it seemed to be that they usually give some suggestion trying to direct you to the particular area of law that they are actually talking about. For example, they may say that what is a tortious liability of this particular person, or these people are considering bringing an action against something. So in the first place, you may see the facts to be like they are narrating a thought or a criminal law fact, but when you get to the last part, the last conclusion will direct you, or sometimes there's some keyword, like we look at even 2 weeks ago, we look at one particular question like that. So they will give some suggestion and it can draw your attention to the area of law that the examiner has in mind. I think that one too.
Yeah. Okay. Yeah. So sometimes that is true, but let's assume that it's not even we don't get that direction in terms of narrowing it for us. Then, since it's a composite paper, then you have to play the 2-card game. Yeah. So thank you. So let's play at 9. No, at 8. Which of the following ingredients could secure conviction of an accused person on a charge of murder? Can someone summarize the law regarding elements of murder for us quickly, just in a minute? Can anybody summarize that for us? The law on murder, what are the constitutive elements? What elements must be established? So only 2 students are doing the discussion. Okay, let me, this new person. Okay. Green grass, yes, you can speak.
Hello. Oh.
Yes. Okay, that's Jalen. Kaylan. Okay.
Yeah, Section 46 of the Criminal Offences Act, some murder, intentional, and then which results. So there are 4 elements actually.
So what are these? Tell us. Okay, I think the sound is there. Okay, now we have Jacob, we have Barrister, we have W. Who is W? Okay, FJ, that's FJ.
Okay, so please, when we look at the case of syringes and another versus the state, they stated the element of
I didn't get that.
syringe and another
Right.
versus the state.
Right.
They stated the elements for murder. That's 1, intent to cause death. 2, infliction of harm.
Okay.
So, in simple terms, there must be a dead person, and the person must die from the harm, the unlawful harm inflicted on the person.
Okay. All right. Okay, so let me also listen to Barrister.
Yes, Doc.
Yes.
I think just to add up to the element they have already listed, intentionally causing harm. The harm is the cause of the death, and that the death might have occurred within a year and then a day. I mean that principle, a year and a day, as in R.N. Dyson.
Yes.
So it's also an element. The year and the day rule is also important. Thank you.
Okay, so the year and day rule will go to like the element of the causation. Okay.
Yes.
All right. Okay, so I think yeah. All right. So which of the following ingredients to secure conviction of an accused in charge of murder? Is that someone is dead? Yes, that one is part of the element. 2, he died from harm. It has to be what you call unlawful harm, isn't it? Not just ordinary harm. But died from harm, that the harm was caused by the accused and no one else. And 4, that accused intentionally caused the harm. Okay. let's look at B. Now, someone was dead. I mean, that one is true. That he died from harm. Good. That the harm was unlawful. Yes, I like that. That the harm was caused by accused, and no one else. And 5, that accused intentionally caused the harm. Okay, so B is a good candidate, but let's keep testing correctness of that against the remaining 2. As I said, that when you seem to have been gotten an answer, don't stop until you have gone through the remaining answers to be very sure what you have is correct. C, that someone was missing after he went out to the accused. That for over a year he has not been seen, so it's presumed dead. No, presumption of death is usually, I think, after 7 years, right? That is an act. And that is why, if you remember Castro, I think Castro has not officially been declared dead more than 7 years after his appearing with his girlfriend or his love. 3, that accused could not give any reasonable explanation as why the person went out. No, that is Zaki who killed the missing person. But where is the body? No, the body is crucial. If there's no dead body, you can't talk of murder. That is 1. Unless you're going to make presumption. And that presumption of death is not conclusive, it's rebuttable, but that 4. So let's say C is completely out. It's not a candidate at all. And we've also been able to knock out A, because the harm there is not qualified. Because if the law, for example, just like capital punishment, you kill someone, you inflict a harm, that one is permitted by law. Or even a war, right? You kill someone, that is permitted by law. Or even like self-defense, you use a force which is reasonable and proportionate and all that to defend yourself and all that, and the person dies, yes, but that is not an unlawful harm, or is a law which is excused. I mean, it's a harm which is justified by law. So that is why A, by elimination method, is not a candidate, a good candidate. It's a candidate, but not a good candidate, so it's knockout. C is not a candidate at all, because we don't see dead body, right? So C is out, out, out. So the competition is now between B and D. So let's look at D. That someone was dead. 2, that he died from harm. 3, that the harm was unlawful. 4, that it was accused who caused the harm. And 5, that accused negligently caused the harm. If the accused negligently caused the harm. Yeah, FJ, is your hand up? FJ, is your hand up?
No, no, sir. Sorry. I think it's there.
Right. Yeah, so it has to be like intentional, isn't it? If it's negligent, that will be manslaughter, isn't it? So we will go for what do you call it? Like the B. B is what could secure conviction on a charge of murder. So it is B. Has anybody got a contrary view concerning B being the most suitable option? Okay, let's go to 9. For me, tomorrow, I won't go to court. I also not go and teach. And if I go to office, I'm just going to do work in the afternoon. That's why I'm spending more time with you. So if you think that you go to work, you can stop. But I'm going to do until I'm tired. But I will upload it on YouTube. Later we can play it back if you want. But if you want to go to work, you can just stop and go. 9, which of the following, in your opinion, does not accurately state the exception to the common law liability of a common carrier? Answer by taking one of the following. Good. So what is the principle of a common law, the common carrier, a common law? Who's a common carrier? Okay, FJ. Your hand is, I think you are omitted. So who is a common carrier? Yes. That, I mean, that's like maybe like the DHL or anybody that you've entrusted something to deliver. That's a common carrier, isn't it? Yes. Who will try for us? Some of you, somebody said that Kayeye. I think you think the common law knows Kayeye. Hmm? Emmanuel, you can tell us the answer, but I don't want to explain. I told you I'm interested in the explanation. Emmanuel, can you put up your hand to explain? Yes. Oh, sorry.
Look,
Yes.
I honestly read this some time back. I have an idea as to the answer, but the principle in it I've forgotten.
Okay. So let's suppose that you went to the exams, okay? And this question has been turned upside down. How will you answer it? Okay, I'm going to read where a common carrier is for you from the Black's Law Dictionary. Let's pay attention. So from the what edition? This is the 11th edition. The 11th edition of the Black's Law Dictionary, page 26. Common carrier. Just listen, right? You start from carrier. An individual organization such as ship owner, railroad, or an airline that contracts to transport passengers or goods for a fee. That's the general meaning of a carrier. Now, common carrier, a commercial enterprise that holds itself out to the public as offering to transport or passengers for a fee. A common carrier is generally required by law to transport freight or passengers without refusal if the approved fare or charge is paid. It's also another term for referring to common carrier is also what they call it the public carrier, right? Public carrier. So a common or public carrier is one who undertakes as a business for hire or reward to carry from one place to another the goods of all persons who may apply for such carriage, provided the goods be of the kind which he professes to carry, and the persons who apply agree to have them carried upon lawful terms prescribed by the carrier, and who, if he refuses to carry such goods for those who are willing to comply with his terms, becomes liable to an action by the aggrieved party for such refusal. To bring a person, therefore, within the description of a common carrier, pay attention here. He must be engaged in the business of carrying goods for others as a public employment. He must undertake to carry goods of the kind to which his business is confined for persons generally, and he must hold himself out as ready to engage in the transportation of goods for hire as a business and not as a casual occupation. And this due to obligation to the public by reason of the public nature of the employment and the increased responsibility imposed upon him by law upon the grounds of public policy, mainly distinguish the common from the private career for hire. So we have the distinction now that the common career is also coterminous with public career. So let's go through the options. A, at common law, the common career is not liable for damage or loss not arising out of his negligence. Okay, in this one, if you don't know the principle, I think common sense can lead to knockout, elimination can lead to knockout A, isn't it? At common law, the common career is not liable for damage or losses arising from an act of God. So an act of God, that is those risks which are out of your hand. But insurance policy will have to be taken. But let's move on. C, at common law, the common career is not liable for damage or losses arising from acts of enemies of states. But B and C are the same, essentially, because acts of God also include what do you call, like the war situation, right? Because enemies of state, we are talking about where people are fighting the state or undermining the state. D, common law, the common career is not liable for damage or losses arising for an inherent vice in the goods carried. Okay, so let's go back to which of the following, in your opinion, does not state the exception to the common law liability of the common career? Okay, so the common career is not liable for damage or losses arising from inherent vice in the goods carried. Of course, if the goods itself has got an inherent problem, that is a concealed or something within it which is already with the good, if anything happens to it, common sense will even tell us that you cannot hold the person who is carrying it responsible. So the common career cannot bear it. But is that the answer? Because the question is asking for an exception to the liability of the common career at common law. Yes, Ezekiel. Ezekiel, is your hand up? Is your hand up or from the previous one? Emmanuel Zaika, is your hand up or from the previous one? Oh. Yes, unmute yourself. Emmanuel, are you
talking about the previous one?
Right. And so as I said, the question is asking us to choose the best statement which can be considered as not being an exception. That is when the common career cannot escape liability. Okay, so let's go through and take ones where we say that yes, the common career can be, but it doesn't also mean that all of them are going to be a good statement of the duties of the common career. So that is another thing that we have to be careful about. So A, as common law, the common career is not liable for damage or losses not arising out of his negligence. Yes, that is true. If he's exercise reasonable care to take care of them, as anybody who is into that business would do, and anything happen, that cannot be blamed on his breach of duty of care. He cannot be held liable. Okay, B, a common law, then the act of God. Losses arising from an act of God, can it be blamed on the common carrier? Certainly not, because act of God, if you have like you have a storm, let's assume it's like by the sea, or even if you like if it's an accident, if an accident happened and an accident was not negligently caused and all that, can the common carrier bear liability? But in modern times, insurance will take care of all these things. Then what about let's look at the third one, that the damage or loss arising from acts of enemies of states. Can it be blamed on the common carrier? No. It cannot be blamed on the common carrier. Let's say that if you have like the terrorists, right? If you have a terrorist and the activities result in destruction, can you blame on the common carrier? But then it will, since, but if we look at the principles that we read, if so long as you have held yourself out as that you do that business, you take a fee for it. If you don't enter into contract or some insurance arrangement to protect yourself from such a risk, the person who has given his things to you will not, for example, entertain anything that these were destroyed by terrorists or people who were waging war against the state. And that is why you have to have a force majeure clause, or you have to have like a policy. So a common carrier cannot escape liability from that. But the D, that if there are inherent defects, that one is not the fault of the common carrier. And the common carrier cannot do anything about it. So if he can show that, yes, the things that you gave me to carry or to transport, already these were the fault in them. And no circumstances can the common carrier be blamed for that, which was already problematic in the subject matter of what he was transporting. And that is what makes like the D not the, was it that's not accurately state exception to the common law liability of the common carrier. Yeah, so why did you choose D? Yes, Emmanuel, you opted for D. Why? Is he gone? Okay, Emmanuel has actually abandoned it. Okay. Yeah, because like D cannot be the question is talking about the sentence is misleading in A. The answer is A. Lily, are you here? Lily, can you put up your hand? So that, yeah, I think you have a point. Lily, is she gone? Yeah, Lily, can you explain your point? You can mute yourself. Lily. She's probably sleeping after putting it in the chat. Okay. Yeah, so as I indicated, my line went off. Yeah, FJ, your hand is up. Unmute yourself.
Okay.
Yeah, I'm allowing to, but I'm back. Yes.
Doc, okay. So a common carrier is absolutely liable for the goods carried by it. Okay. But there are 4 exceptions. That's act of God, act of public enemies, okay, fraud, and an inherent defect in the goods. Those are exceptions that cannot be blamed on him. So if the goods were negligently like spoiled or destroyed because of his actions, that's when he's liable.
Okay, good. But
So
A says that he's not liable for damage or loss of not arising, isn't it?
yes, it's confusing.
So not arising out of his negligence. So if they did not arise out of his negligence, he's not liable.
Yes. He's not liable, but he's the one carrying the goods.
Yes.
So at that point, even if the negligence is not from him, since he's in possession of the goods,
yes,
he has to answer for it.
Okay.
That's what I think.
Okay. So if you look at some of the literature, some reason along the lines that you have told us that the liability of the common carrier begins when the goods are delivered to him for carrying and accepted by him in capacity of a carrier. And then he begins with the exception, except when the loss arises from any of the following causes: by an act of God or by public enemy. So public enemy, if you like, will be the those who are waging the war, or by the act of the shipper. So act of the shipper will be like the negligence, right?
Yes.
With the negligence. Or from the nature of the goods. So from the nature of the goods will be like the inherent, how do you call it, the defect. So so D is a recognized exception to liability. C is a recognized exception to liability. B, a recognized exception to liability. So under the circumstances, that's why the fact that there's some sort of infelicity in how A is catch vis-a-vis the question tax master. A is the correct answer.
Yes, please. Doc, please, that your screen is off.
My screen is off. Oh, really? Okay. Okay, so as I said, like the A will be the correct answer because B, C, D fall within the traditional exceptions to liability. Which of the following is not true in respect of the determinable title? I think we closed at exactly 1. Which of the following is not true in respect of determinable title which a stranger may acquire by grant from a stool or subject of a stool? So we are going back to land law. And I'm sure at this stage, all of you are experts in the land law, having read the Land Act and the related literature over and over. Yeah, so you remember the usufructuary interest, otherwise also known as the, out of which you can also have what they call like the determinable title, or another way, some customary freehold, usufructuary interest, determinable title, and all that. And you know that as a general rule, it is only those who are members of the family, the stool having that can enjoy it. But if you have a stranger, the stranger should be prepared to perform the customary services, which are usually rendered by subjects of the stew or members of the family. And in modern times, maybe the customer services, which in the past you have been maybe going to war and other things, will have to be maybe like the payment of money or some other things. So which of the following is not true in respect of the determinable title which a stranger may acquire by grant from a stew or subject of a stew? Okay, so A, the determinable title which a stranger may acquire by grant from a stew or subject of a stew places him in almost the same position as the subject. Is that true? The same position as the subject in terms of the customary services which the subject will have to render, then the stranger too will have to render that. But let's move on to B. If a stranger who has acquired a determinable title abandons the land or dies without any family to succeed, the land will revert to his grantor or to the grantor's family. Yes, that is true. That is true. C, the stew or subject of a stew who owns the determinable title who grants the determinable title to a stranger may alienate that land or any other person, to any other person, subject or stranger, without consent of the stranger grantee. No, that is not true, because if it made like a grant to the stranger and he's performing the customary services and all that, you cannot just take it away from him just like that. No. D, in respect of agricultural land as well as building land, the title of the stranger grantee is limited to a well-defined area demarcated to him upon grant. That is true, because unlike the what do you call like the subjects or the family member belonging to the family having a lodia or the stew having the lodia, that is why we say that if you look at some of the old customary law textbooks, that you know the extent of land that you can get is where you are marshed, cutlass, or where you can weed up to. So, but that one is for the family member or like the subject, not necessarily you the stranger, that you can take as much as you want. I think not that is not true. So if the question is saying that which of the following is not true in respect of which may get yes. So which ones have you marked out as true? Yes, we mark B as true. We said that the C is not true. Yes, yeah, because C is not true. Yeah, so let me look at your answers. Oh, you can't see. Oh, really? You can't see the screen? FJ, did you say you can't see the screen? Hello, can you see the screen? Yeah, Bella, can you see the screen? Can you see the screen? Okay, all right. Okay.
Yes.
Right, okay. Yeah, Bella, your hand is up. FJ, your hand is up. Okay, so Bella first. Yeah, Bella, you can speak. Your hand is up. You can speak. You can mute yourself. Just click the mic. You'll be unmuted. Okay, I think she's gone. Okay. FJ, okay, you can mute yourself. Yes, let's hear you. FJ, let's hear you. Yeah, so A is true in almost the same position as the subject. That, and the emphasis is in almost. It did not say that the same, right? So A is true. FJ, do you want to speak? Do you? Yeah, the internet is bad. We'll be ending very soon, don't worry. Yeah, so what we're trying to do was to just flag the true one so that we have like the answer. So we've said like the A is true, so that is not the answer. B is true, so that is not the answer. C is not true. C is not true, so C will be the answer because D is true. Okay, so it's now 5 minutes to 1. We end the class there. So have a very good morning. We'll continue another time. Daniel, okay, all right. So Daniel is gone. Let's end.
I was thinking we.
Yeah, I wanted this to end. Yes. You have some. All right. Okay. All right. Thank you. So God willing, tomorrow we continue. Good morning.